Also, the handouts you receive today will contain the information I'm about to provide to you, as well as other pertinent information. The underlying points to always remember when you are thinking about your duties as guardian of the estate are as follows. First, you are dealing with someone else's money. Second, you are required to show the court what you have done with that money. And third, you should always consult your attorney if you have any questions about the use of the ward's funds. Keep estate assets separate. Keep in mind that you must keep the money and property separate from everyone else's, including your own. When you open a bank account for the estate, the account will be in your name as guardian of the estate, not in your individual name. The account will be connected with the ward's social security number and not your own. Never deposit estate money in your personal account. Never mix estate money with yours or anyone else's, even for a little while. Remember that securities must be held the same way that the guardianship bank accounts are held. Interest-bearing accounts and other investments. You can set up checking accounts for everyday expenses, but put the rest of the estate's funds into accounts that earn interest. These are commonly known as interest-bearing accounts. Use only FDIC-insured accounts, and don't put more than $100,000 in any single bank. Always talk to your lawyer before you make any investments for the ward.
That's the age of majority in Louisiana. So technically the surviving parent has the right to designate the guardian. That comes up in, when parents are divorced. But the surviving parent has that right, and they typically do it either in their will, that's most common, or in some other declaration that's notarized and witnessed by two people, and so we've done some of that as well. When parents need to do it really quick, they're going on a trip. So that's where you get to designate who's going to raise your children, who your children are going to live with. I know all parents want to have a say in that, but you've got to put the legal plans in place. The second of 5 components is we got to make sure we comply with these forced heirship provisions, which are unique to Louisiana. Because while most people say, well, I want what I have to be for the benefit of my minor kids, what the forced heirship rules don't allow you to do is leave everything to your spouse. Can't do it because you have these forced heirs. So you got to make sure you set all that up the right way. Third component is all parents with minor children, virtually all parents, when they engage in estate planning, they set up trusts for their kids. So a judge doesn't have to oversee how the inheritance gets spent, and the money's not dumped into your child's lap on their 18th birthday. Happy birthday, probably gone when they're 19. So most parents set up trusts, and there's a gazillion different ways to set it up, but sometimes parents of minor children, as part of their estate planning, say, well, if we pass away, we want our assets to go into a trust for our kids. We want my sister, my mother, my trusted friend to be the trustee. We'd like that trustee to use the funds for our children's health, their education, their maintenance and support. And then once our children reach a later age, maybe they say 25, maybe they say a third at 25, a third at 30, a third at 35. Maybe they say in their trust they want the trustee to have discretion to determine when the children get it. Then the children get it at a later age, hopefully more mature. They're able to benefit from it over a very long time, but have their important educational needs taken care of. So a lot of options there. So those trusts can be set up as part of a parent's will, called a testamentary trust. It's a trust that's in their will. Or it can be set up as a separate trust, and maybe the will references that trust, or maybe that other trust is part of the parent's revocable living trust because the parents want to eliminate the relatives and the kids from having to go through that probate or succession when they die. So a few options there. Need to talk about that. And then a couple of other things. Number 4 is all parents with minor children need to have powers of attorney in place. It's a disaster if you become incapable, car wreck, injury, illness, whatever. You're not able to sign your name, deal with a sale of your vehicles or your home, not able to request medical records from your doctor. So virtually all parents with minor children have these powers of attorney in place. It's where you designate who you'd want taking care of your business and taking care of you if you're not able to take care of these things for yourself. Most married couples appoint their spouse first, but real important to name a backup. again, may be a trusted family member or friend. As you get older and your kids get older, they get into their late 20s, they're more mature, you'll likely have them fill some of these power of attorney roles as opposed to others who would fill them because your kids are minors. And then maybe the last piece that we address with everybody is that living will declaration, which is the statement about life support machines. You may not want to put, an 18-year-old as being responsible for making that decision to withdraw life support machines. If you're in that profound comatose state, you got no chance of recovery. Machines are just artificially prolonging the dying process. A lot of, parents get a lot of comfort in documenting their wishes, directing their family and their doctors to follow it. Keeps the children from having to make that really tough decision that may linger on for some time. So there you have it.